Good morning and welcome to episode 74 of our Case of the Week series, published in partnership with 𝐂𝐞𝐧𝐭. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant and the principal at ESI Attorneys. Thanks so much for joining me today. I hope you're having a fantastic summer. As you know, on our Case of the Week series, each week we choose a recent decision in eDiscovery that highlights key issues for litigators and those involved in the eDiscovery process. And we try to talk about the practical implications of that decision for you, your practice, and for your clients. Today, we've got a really important decision on one of our favorite topics at Case of the Week, which is Federal Rule of Evidence 502D. As always, you can find the link to the public link from our eDiscovery Assistant database to the decision in either the post or the comment, depending on the platform you're viewing us on, whether that's on YouTube, Facebook, LinkedIn, or Twitter. You can also find today a link to the article from Doug Austin at eDiscovery Today, who's also written about this decision. All right, let's get into this week's case. Our decision this week is very recent. It comes just from last Friday, July 22nd, 2022, and is the latest decision in the eDiscovery saga that is DR Distributors versus 21st Century Smoking. This case is, of course, from the infamous Judge Iain Johnston, who's a United States District Judge in the Northern District of Illinois, also in the Seventh Circuit. As we know from previous episodes on Case of the Week, Judge Johnston writes incredibly thoughtful decisions and incorporates both common sense and a sense of humor into his writing in really setting out what the facts are and how they bear on the law. As always, for our Case of the Week, we talk about how many decisions a judge has in our database, as well as the issues that have been added to that decision in the database. This is the 9th case that Judge Johnston has in our database, many of which are from the DR Distributors case. And the issues for today's decision include Federal Rule of Evidence 502D, attorney-client privilege, redaction, clawback, privilege log, in-camera review, and waiver. Okay, I've already mentioned that we frequently cover Judge Johnston's decisions on the Case of the Week. He, of course, wrote the infamous DR Distributors case that we discussed back in February of 2021 on the motion for sanctions between the parties. Judge Johnston also wrote the Hollis versus 𝐉𝐮 Logistics decision that was covered on episode 71 of Case of the Week. And my hat is off to Judge Johnston that he maintains his sense of humor, even in what must be a very frustrating slog through the decade-long fights in this DR Distributors case, in which he has referred to in an earlier decision as the ESI food fight of Hollywood proportions. I'm going to urge you to read today's decision. As always with Judge Johnston, the facts are plentiful, and I've tried to parse through them to give you as much as I can to set the stage without making your eyes glaze over. But this decision has many excellent nuggets, some of them even in the footnotes, and it's a very important case on Federal Rule of Evidence 502D. Okay, so what are our facts here? We are before the court on the plaintiff's motion for an order deeming the marital privilege waived in production of documents. The issue for the court to resolve is whether the defendants waived the marital communications privilege, by disclosing numerous electronic communications to the plaintiff during discovery, and if so, to what extent the privilege has been waived. The underlying case here, if you can't remember, it involves claims by DR Distributors that 21st Century Smoking infringed on its trademark. Both parties compete in the electronic cigarette industry. 21st Century Smoking is a small company that is owned and operated by Brent Duke. Mr. Duke was front and center on the motion for sanctions on our previous coverage on the Case of the Week. Brent Duke's wife, Lori Duke, also works for the company, and many of the emails produced by the defendant, as the court notes, detail marital strife, specifically with regard to Lori's criticism of Brent's business decisions for 21st Century Smoking and how they impact the bottom line for the business. The plaintiffs are interested in emails from Lori that are criticizing Brent's decisions and how they impacted the company performance at 21 Century Smoking, because they are relevant to defend against defendants' counterclaims that the plaintiff has harmed them. All right, so with that background, let's look a little bit at the timeline of this case. Going back to some of the previous decisions, this case was originally filed in 2012. Discovery closed July 1 of 2015. Prior to the close of discovery, the court notes that marital privilege was never an issue, and there were no privilege logs that claimed any sort of marital communication privilege prior to the close of discovery. On May 31st and June 1st of 2018, the defendants then produced thousands of emails after failing to do so on multiple occasions. From that production in May and June of 2018, the former defense counsel withheld 16 emails and redacted 32 additional emails based on marital privilege. That is the first time in this case that marital privilege has been raised. That production also included emails that included marital communications that were not identified on the privilege log. After these productions, defense counsel learned that production had not been made from a GoDaddy account and then withdrew. So we had these productions in 2018. We subsequently had the motion for sanctions in which defense counsel learned that his client had not been forthcoming with all of the information about sources of ESI, and so that counsel withdrew. New counsel took over as of August 8th, 2019. Plaintiff then filed a motion for sanctions. Both plaintiffs' brief included at least one exhibit that was an email between Lori and Brent Duke. The new defense counsel then responded to the motion and also attached emails that contained marital communications to their response brief. Okay. On November 13th, 2019, 2 days before the hearing on the motion for sanctions, current defense counsel then produced an additional 30,000 documents to the plaintiff. At the motion for sanctions hearing 2 days later, the plaintiff introduced exhibits that included marital communications, and at that time, the defendants made no objection to use of the documents based on the marital communications privilege. Fast forward to October 23rd, 2000, the court informed the parties of its anticipated ruling on the motion for sanctions and told the defendants that would have 30 days to find and produce responsive documents once the order was entered. And the court also gave the parties the opportunity to settle at that time. Parties did not settle. The court then advised that it would enter the sanctions order on January 19th, 2021, and that the defendants had 60 days prior to that, so from November to January, to know that they would have to find and produce documents within 30 days. The court then issued the sanctions order on January 19th. That's the decision that we covered on Case of the Week in February of 2021. That started the clock for the defendants in terms of production. Defendants did not meet their 30-day requirement. They sought an extension and subsequently produced on March 19th, 2021, thousands more documents that were previously responsive in discovery. At that time of the March production, the defendants also withheld documents for privilege, including marital communications privilege, as well as redacted documents based on the marital communications privilege. So in that production in March, we had documents withheld for attorney-client privilege, also for marital communications privilege. At some point after that March production, I believe in July, the defendants then sought to claw back 267 documents relevant to the motion, 148 of which were based on marital communications privilege. But the only evidence that was provided in order to claw back was a declaration from defense counsel. That declaration stated that defense counsel had inadvertently produced marital communications without the intent to waive the privilege, but did not provide any supporting facts as to why the production was inadvertent or what steps were reasonably taken to prevent the production of privileged information. The plaintiffs then objected to the documents that were withheld on marital privilege grounds, and the court ordered an in-camera review of the unredacted versions and withheld documents of all of those that were withheld based on marital privilege. The court then reviewed those documents, as it noted, over an entire weekend and found that all of the documents were covered by the marital privilege. The court at the same time, or at one point as we're going along in this case in 2019, the court on its own entered a Rule 502D order to protect the parties from inadvertent disclosure. Now, what's going to be crucial here is the language and title of Rule 502D, as well as the comments, the committee notes to Rule 502. The Rule 502 is titled Attorney-Client Privilege and Work Product, semicolon, Limitations on Waiver. So that's the total title of the rule. I don't know that we've really paid attention to that prior to Judge Johnston's decision here. But what's going to be really crucial is that we're going to find out that Rule 502 is in fact limited to attorney-client privilege and attorney work product doctrine in terms of protection against waiver. Further to that point is the opening language of the rule, which states that, quote, the following provisions apply in the circumstances set out to disclosure of a communication or information covered by the attorney-client privilege or work product protection, close quote. The committee notes to the rule also note that, quote, the rule seeks to provide a predictable, uniform set of standards under which parties can determine the consequences of a disclosure of a communication or information covered by the attorney-client privilege or work product protection, close quote. The committee notes go on to state that they are not providing guidance on other aspects or privileges that may constitute waiver. And the court notes that in its analysis. Okay, so those are our facts. Let's talk about the court's analysis here. The court begins its analysis by defining the marital privilege as covering communications privately disclosed between a husband and wife in the confidence of the marital relationship. The marital communications privilege exists to ensure that spouses feel free to communicate their deepest feelings to each other without fear of eventual exposure in a court of law. That's the language that's cited by the court in this decision. I make no commentary on whether or not I believe the marital privilege should only be between a man and a wife. The court then notes that the defendant bears the burden of showing that no waiver occurred as a result of the inadvertent production. And the court also notes that the marital privilege can be waived by disclosing the communication voluntarily. The court then goes into the applicability of Rule 502D to this situation. And of course, that comes up because the court, sua sponte, issued a Rule 502D order in the case. The defendants then relied on that 502D order that the court had issued in order to essentially look for a scapegoat for their inadvertent production of documents that included marital communications. And the court says that there are really two reasons that it believes that the defendants relied on that. That one, 502D is a more generous standard to claw back documents, and two, that it bolsters their detrimental reliance argument, essentially that this court's order entering a 502D order would be applied to the fullest extent available, cause them to be less careful. And the court then identifies three problems with that position. First, as the plain language of Rule 502 makes clear, the rule only applies to the attorney-client privilege and the work product doctrine. It has no effect on any other evidentiary privilege, such as the vast array of governmental or other common law privileges, including the confidential marital privilege. The court notes that the terms attorney-client privilege and work product protection are even defined in the rule. And the court also points to the advisory committee notes that we mentioned earlier that provide the same answer, that the rule is limited to the attorney-client privilege and the work product doctrine. Second, the court notes that the order that it entered on February 2nd, 2021, putting the 502D protection in place for the parties, had absolutely no effect on any documents that were produced prior to that order, including those in November 2019. Remember, we've got three productions here that are at issue: May and June 2018, November 2019, and March 2021. As such, that order that was issued in February of 2021 could not have caused the inadvertent production in November 2019 because it was not in place at the time the production was made. Third, the court notes that assuming Rule 502 applied to the marital communications privilege, which it does not, a simple cost-benefit analysis counsels against blindly relying on a Rule 502D order to justify the failure to implement a reasonable document review process. The court goes on to cite some decisions where courts have allowed parties to claw back inadvertently produced privileged materials without a showing of reasonable efforts to review privileged materials, but also cites other courts that have found that despite the existence of a 502D order, a completely reckless disclosure can result in waiver. The court then cites the SureFit Products case that we covered on episode 73 of the Case of the Week, decided just 2 months before last Friday's decision from Judge Johnston here. The court then goes on to state that other courts have gone further and explicitly rejected the notion that a 502D order will allow for the clawback of attorney-client privileged and work product protection documents, irrespective of the reasonableness of counsel's privilege review process, or if one even existed at all. The court notes that additionally, counsel who simply dump documents on opposing counsel without first conducting a reasonable privilege review may get in hot water with attorney regulators. The court notes, quote, counsel who produce documents without a reasonable privilege review do so at their own risk, even when a 502D order exists. The chances of being struck by lightning might not be great, but when it happens, the consequences are significant. So why risk walking around in a thunderstorm? Close quote. Based on all of that analysis, the court declined to graft a Rule 502 onto another common law privilege, such as the marital communications privilege, and stated that if the drafters of Rule 502 wanted the rule to apply to other privileges, they could have stated so. Instead, they specifically chose to state that the rule does not apply to other privileges. Okay, so now we know Rule 502 does not apply to the marital communications privilege. And since it does not apply, the court then turns to a 3-part balancing test used in the Seventh Circuit before the promulgation of Rule 502, which requires that all 3 elements of the balancing test be met. And those 3 elements are, 1, whether the document is privileged, 2, whether the disclosure of the document was inadvertent, and 3, whether the privilege was waived. So let's go through each of those elements. With regard to the privileged nature of the document, the court has already reviewed all of them in camera and found that all of the marital communications are privileged. With regard to the next prong, which is inadvertence, the court notes that there's really no bright line rule for determining whether a disclosure was inadvertent, and instead courts really look to the surrounding circumstances of the disclosure. Factors for the court to include in consideration of that are the number of documents produced and the care with which the pre-production document review was performed. The court notes that the parties must use utmost care in selecting the methodology for reviewing documents for privilege, and that simply running keyword searches may not be enough. The court then also cites to the Sedona Conference commentary on privilege, and quote, to avoid a potential waiver of privilege and to avoid the damage that can be caused by an inadvertent production, whether or not the production results in waiver, the parties and their counsel should design and implement a reasonable and auditable procedure for the identification and logging of privileged documents, close quote. That comes directly from the Sedona Conference commentary on privilege. The Sedona Conference then goes on to identify several factors to consider in reviewing ESI for privilege, all of which are laid out by the court here. First, to include steps to identify privileged ESI in the collection process. 2, to create and implement a document review protocol that includes an experienced senior attorney who is charged with oversight responsibilities for implementing the protocol. 3, educate and train the review team that includes detailed discussion on the law of privilege. 4, apply an escalation process that uses more experienced counsel to resolve privilege issues. 5, segregate privileged information. 6, use quality control and sampling processes under the direction of a senior attorney. 7, use advanced analytical software applications and linguistic tools to screen for privilege. 8, contemporaneously document the privilege review process and consider disclosing the privilege review process to opposing counsel. And number 9, citing our colleague Phil Favreau at Driven, the court says that, quote, in a nutshell, counsel should design an internal privilege workflow that is consistent with an established protocol, close quote. And that's an excellent way to think about it. And it's a theme that we've talked about here on Case of the Week multiple times in dealing with privilege information. Okay. So looking back at those are the factors of whether or not we've met inadvertence under the balancing test. The court then looks at what the 5 factors are for meeting waiver under the balancing test. First, the reasonableness of precautions to prevent disclosure. 2, the time to rectify the error. 3, the scope of discovery. 4, the extent of the disclosure. And 5, the overriding issue of fairness. Now, with those 3 steps of the balancing test in place, the court then analyzed the 3 productions made by the defendants under those balancing test requirements. Again, we're talking about the May-June 2018 production, the November 2019 production, and the March 2021 production. Okay, as the court starts its analysis of those 3 productions under this balancing test, it notes, quote, again, the parties have been unclear as to some critical facts. So the court has combed through the filings to find the relevant facts to apply the factors to the 3 different productions that apparently resulted in the, quote, inadvertent, close quote, disclosure of ESI containing privileged communications, close quote. I mean, that's not what you want to hear. You don't want to hear that you've failed to put any facts before the court and required them to dig through the record and be able to set the stage for the facts in ruling on your motion. Okay, starting with the May-June production, the court could not identify which documents had actually been clawed back. And the court said that assuming the documents were privileged, that the defendants had failed to meet their burden to show that the production was inadvertent and not waived. As a result, for that production, the defendants waived privilege with regard to any documents in that production. And the court does not distinguish here between attorney-client privilege or marital communications in denoting that waiver. The court then turns to the November 13th, 2019 production. And again, the court has already determined that those documents are privileged, but again finds that the defendants have failed to meet their burden to show inadvertence or waiver. According to the court, quote, no evidence has been presented as to any aspect of this document production or the privilege review process. And defendants did not seek to claw these documents back until June and July of 2021, more than a year later. Despite being privileged, there is no evidence that the production was, quote, inadvertent, and defendants have failed to meet their burden that the privilege was not waived. These communications can't be clawed back, close quote. Court then turns to the last production, which is the March 19th, 2020. I think I inadvertently said 2021 earlier. It was 2020. The court notes that several of the documents in this production are sought to be clawed back, but also included third parties, and that as a result, they are not covered by the marital privilege, so they cannot be clawed back. There are remaining emails from this production that the court finds are privileged, and then the court turns to whether or not the defendants have met their burden of showing inadvertence and waiver. The court notes with regard to this March 19th production that the only evidence that the defendants provide is in an affidavit from defense counsel, which says, quote, in the rush to properly comply and while under the threat of sanctions for failing to comply, I inadvertently produced numerous marital communications between Brent and Lori Duke. My production of such communications was not done with the intent to waive the marital communications privilege, close quote. The defendants argue in their brief with facts that the volume of documents involved was substantial, that defense counsel lacked any system to document what they reviewed and produced, and that the review and production processes were complicated, especially because they were done remotely during the pandemic. However, the court notes the defendants provided absolutely no affidavits or any documentary support for their propositions, and that the arguments of counsel are not evidence. Simply put, there's no information here provided by the defendants. And the court notes that it has no idea what the privilege review process was or how it worked. And the court says, here are just a few of the unanswered questions. Did defendants use a keyword search? And if so, what were those keywords and why were they chosen? Did defendants use technology-assisted review as part of the review process and then follow up with keyword and or manual review? Did defendants use any advanced analytical software applications or linguistic tools as part of the review process? And if so, what were they? Who used them? How were they used? And what were the results checked for quality or audited in any way? Did defendants use a manual privilege review? And if so, how many attorneys were used? Who were they? How were they trained? What was their work experience? What was their knowledge of the case? And was their work quality checked and audited? And if so, by whom? This is fundamental information that courts need to determine the reasonableness of a privilege review process. The court also points to the lapses in time before counsel sought to claw back the documents, as well as the numerous examples of repeated, inconsistent, and often conflicting redactions that are strong evidence that a standardized and audited protocol was not used. Both of those facts weigh in favor of waiver. The court notes the defendant waited 4 months until time had passed to claw back the documents, including 2 months after the plaintiffs notified defense counsel of the issue with the marital communications. The court notes here that scope of discovery is consistent for an 8-figure case in civil litigation, and that the defendant's dawdling and responding did not help their cause. The court also looks at the extent of disclosure and says that that weighs in favor of waiver, noting that the defendants disclosed hundreds of privileged documents, not just 1 or 2. And the court called the production of privileged materials systemic and noted that the volume of disclosures, particularly when considering the substance of the disclosures, evidences a fundamental failure in the privilege review process. So the extent of disclosure also weighs in favor of the waiver. Fairness, the next element to be considered, also weighs in favor of finding waiver. And the court states, quote, "This court used utmost fairness when, in its discretion, it did not impose harsher sanctions on defendants for their misconduct. Finally, to the extent defendants' counsel misunderstood the scope of Rule 502, that's not a fairness issue. Instead, that's a competency issue," close quote. That's a really important point there to take away from this decision from Judge Johnston. It is your obligation to understand the scope of Rule 502 and be able to use it effectively for your clients and to understand its limitations. Here, however, the court is very generous in saying that it was very fair in its 2021 sanctions decision that we covered here on Case of the Week. I think there were a number of us in the industry who were shaking our heads, scratching them about the sanctions that were issued there. And so for the court to acknowledge here that he exercised a great deal of fairness in those sanctions is very compelling. Okay. The court then considers, finally, the scope and consequences of the waiver here and asks, what happens now that the court has found waiver of marital communications privilege? The plaintiff wants to argue here that the waiver of the marital communications privilege means that defendants have also waived subject matter jurisdiction for those particular documents. The court says no and points to 3 errors in the plaintiff's argument. First, the court says that the plaintiffs have a tendency to, and have done so again, dramatically overreach in this case, and it's been going on for the entirety of the action. Second, the court notes that the plaintiffs attempt to broadly define the subject matter to, quote, communications about the operation of defendant's business, close quote. And that is a really overbroad when a waiver requires a very, very narrow scope. Thirdly, the court notes that the plaintiff mistakenly argues that defendants are using the privilege as both a sword and a shield. And the court is kind of miffed at this. He notes that he's addressed the specific issue before. And the court states that relying on luminaries like Magistrate Judge James Francis, the court found that for subject matter waiver to occur, there must be an affirmative attempt to use communications protected by a privilege to influence a decision maker. In this case, the court. The court found that the defendants had used only one document and then only to provide context at a sanctions hearing, that they haven't produced those documents before 2021. So they have not tried to use them to influence the court now, and they won't be because they are devastating to the defendant's case. Finally, the court had already ordered that the defendants could not use the documents in its previous sanctions motion, previous sanctions order for failure to produce. So in essence, subject matter waiver was not appropriate. Court's final ruling was the plaintiff's motion is granted in part and denied in part. The defendants cannot claw back the emails, but the court does not find that the defendants waived the subject matter. Nothing in this order should be viewed in any way as an indication on the admissibility of those documents, and defendants have not waived any objection as to admissibility. So, huge waiver of the marital communications privilege here by inadvertent production and failure to have and document a process. So what are our takeaways? As I mentioned, this decision raises the unique issue that 502D does not apply to privileges outside of the attorney-client privilege or the work product doctrine per the language of the rule, as well as the committee notes and its legislative history. It's also not a get-out-of-jail-free card in all jurisdictions. You need to understand how your jurisdiction views coverage of the 502D order and whether it requires a showing of reasonable efforts to meet your burden of inadvertence and waiver under the balancing test that's applied by the court here. Does your jurisdiction offer blanket coverage? As this court points out, there are at least 3 different approaches that a court can take to coverage of a 502D order, and you need to understand which one you're dealing with in the jurisdiction where your case is pending. Okay, next, and we've talked about this multiple times on the case of the week, you need to have a plan and process in place for identifying and tagging privileged documents and the basis for privilege. If you wait until after you've produced your documents to focus on privilege, you have waited far too long. Privilege needs to be a consideration at the very early stages of identifying documents, collecting them, and loading them into a review platform, as well as training your review team. If you follow those steps that are outlined by the Sedona Conference commentary that the court lays out here, you're going to be in a much better situation to be able to deal with an inadvertent production under 502D, even in a jurisdiction that requires reasonable efforts. Now here, one of the things that struck me was the defendant said they had no system in place to be able to track produced documents or withheld documents. I mean, that's something as simple as using a spreadsheet. I mean, a spreadsheet can be used to capture any of that information, and information like that can be pushed from the review platform out into an Excel spreadsheet that you can then use as a production log as a way to continuously track what's happening for purposes of a case. Many people in the industry use something as simple as spreadsheets. You don't even need a more sophisticated piece of software to be able to track what you're doing, what decisions are being made. Use a different tab for each one of the ones that you need. Use a privilege tab for here are the decisions made on privilege. Use a production log tab for here's what the production log was. Use a privilege log tab for each of the individual entries on the privilege log. Date them so that when you have multiple privilege logs, you know which one is which, and then be able to combine them for purposes of the end of the case. Okay, finally, and this is one of our themes, you have to put the facts before the court to allow the court to do the analysis. I mean, here the defendants didn't put any information to the court on the process for identifying privileged documents. And while it may not have met the court standard for reasonableness, there had to be at least some process here because the defendants did provide a privilege log. By leaving out all those facts and relying solely on arguments versus affidavits, the defendants really left the court with little choice on the issues of inadvertence and waiver because there were just simply no facts put forth by the defendant to meet their burden. Lots of great information and things to think about from a practical perspective in this decision from Judge Johnston. So I encourage you to take a look at it. All right, that's our case of the week for this week. Thanks for sticking in there with me for a longer decision. We'll be back again next week with another decision from our eDiscovery Assistant database. As always, if you are an ACEDS member and interested in using EDA, you can look at your portal to determine information on trial and a discount associated with being an ACEDS member. If you're interested in doing a free trial of our case law and resource database but are not an ACEDS member, you can just jump to eDiscoveryAssistant.com and sign up for a free trial to get started. Otherwise, you can reach out to our team at support@eDiscoveryAssistant.com and we'll set up a special demo for you. You can also join our public demos available on Thursday mornings at 11:30 Eastern Time directly from our website. Thanks so much. Stay safe and healthy out there, and I'll see you next week.